Thanks for joining us again this morning. We're going to pick up where Norman left off last night. So he did Article 1 and Article 2. We're going to talk this morning about Article 3, the judiciary. And we'll also pick up sort of where I left off 2 nights ago and really focusing on the abortion decision or the pro-life decision of Dobbs and how that characterizes or helps describe what good justices do. So not only will we talk about the makeup of the court in Article 3, but we'll analyze what a good philosophical view of the law is and what a good opinion looks like by actually going through the Dobbs decision. So of course on Friday, June 24th, 2022, the Supreme Court of the United States wrote in Justice Alito's words that the Constitution does not confer a right to abortion. And in those words, the entire framework of abortion was shattered. An entire industry that rested on the Roe v. Wade decision had the rug pulled out from underneath it with those very words. And it's in such recent memory that I'm sure all of you remember exactly where you were and exactly what it felt like, exactly what you thought of when that decision came out. You know precisely exactly what that feeling was. But still, it's going to take time for us to really unpack and understand what it means for the culture and what the reaction of the states will be, what the reaction of other judges that have to rule based on a Dobbs decision have to do going forward. Really, my immediate thoughts were the hopes and fears of all the years are met in thee tonight. It's from that Christmas hymn, O Little Town of Bethlehem, where they talk about this little place in Bethlehem where all the hopes, all the fears were met in that one place. Well, that's really how I felt about that one square block in D.C. where the Supreme Court is, that the hopes and fears of all the years seem to be met in that one place. But immediately, what you also probably heard from the other side was that, well, the court is illegitimate. This court is illegitimate. How dare they? This court is illegitimate. Hearing that no makeup of lawyers, even if they're wearing robes, should be able to dictate the rights to an entire country. And of course, you and I know that's not what happened. It wasn't just lawyers dictating rights to a country. But how do we articulate that? How do we properly give a defense of what the justices actually did and defend that what they did was the right thing? Because if we don't get that part right, if we aren't able to give a good argument for why the justices ruled that way and why they will opine further consistent with the rule of law, we're basically going to be bouncing back and forth, and it's just going to be a shouting argument based on whether or not we agree with what they do or if we disagree with what they do. Basically, we'll be shouting back and forth, you know, my court's bigger than yours or my court's better than yours, and not really get to the meat of what the court actually ought to be doing. So this is how you give a proper defense of how Article 3 works and how the judiciary works. We're going to really dive into Article 3 of the Constitution. So this is preserving an independent judiciary, a defense for Article 3. So let's get started. In the beginning, God created. Just kidding. not so much, right? Let's talk about the history of the judiciary. So it's not just this past July that we started regarding what the justices were doing and what the Supreme Court did as an understanding or an interpretation of the Constitution. This idea of an independent judiciary has always been a stalwart feature of the U.S. Constitution and our system of governance. Article 3 explicitly provides for one Supreme Court. It says that the authority to interpret and that the judicial power of the United States is vested in one Supreme Court. And then it says, also in such inferior courts as Congress from time to time may ordain and establish. So one Supreme Court, and the fact that they expressly provided for one Supreme Court at least showed and revealed the founders' understanding that it's going to have an important role in our system of governance. And despite setting these parameters, saying that there is going to be one Supreme Court, they still left it up to Congress to decide the details of what that court makeup would actually be. They left it up to Congress to decide what the size of the Supreme Court will be. And so over the years, it's gone back and forth. It's had different size makeups. From the early days of the Republic, there were just 6 Supreme Court justices, and that was compared to the 3 circuit courts that they were. So there were 6 justices with 3 circuits, which essentially meant that the justices were to ride the circuit. These circuits were in different regions of the court, and so 6 justices, 2 justices for every one of the 3 circuits. So how did we get from the number 6 to 9? Well, as these population expanded across the United States, so did the circuits. They added more circuits, so you needed more justices to ride the circuits, and so you got from the number 6 to 9. It's not necessarily an arbitrary number. It was based on the growing population, but at least since 1869, that number has really stayed at number 9. Of course, it has some rationale to it, but it is still in the purview of Congress to see whether or not we need to expand the court or keep it the size that it was. But at least for the past 150 years, it has stayed at 9. But now you hear from Democrats, of course, that aren't getting their way, well, we need to expand the court. We just need to add more justices. We have to expand the number of justices, but it's not based on the growing population. It's not based on the inability of the justices now to do their job. They want to expand the court just so they can basically get their way. And so they started with accusations. They said, well, Donald Trump packed the court, right? He added 3 Republican justices. He packed the court. We should be able to pack the court or expand the court as well. But in reality, all President Trump did, all any president does, is appoint justices that they understand will have that philosophy of law that they agree with. And so a Republican president can put as many justices on the court as there are vacancies. And at the same time, if a Democrat president comes in, he can do the same. And of course, Biden had a criteria of who he wanted to be on the court. And so he had the opportunity to place someone on the court that he thought would follow his specific philosophy of law. So neither what Trump did or what Biden did is at all packing the court. What packing the court really is it's relatively arbitrary, right? It has no consistency with the growth of the population. It's basically one side saying, even if there are no vacancies, I'm going to throw as many justices on the court as I possibly can, as many as the Senate will confirm, so I can have more folks on my team ruling the way I want against the other folks that are ruling the way that I don't want. So it's not based on a growing population. It's not based on the inability of the court to do its job with 9. They can clearly do their job with 9. Really, it's just being tied to a band of disgruntled folks that are dissatisfied with what the court is doing, and so they want to add more people. They want to counter the votes for the bad decisions that they say are coming from the court. And if you do that, the court loses its legitimacy, right? It's only based on how many justices that particular president or that particular issue of the day or that particular group wants to get on the court. And the court will no longer be independent. It would be based on whatever winds of change are occurring at the time. And this isn't new in history, right? We saw that under FDR. The most recent severe threat to expand the court happened under FDR in 1937. FDR wanted to push through these New Deal progressive ideas. And so he brought this in front of the legislature, went all the way up, and the court was like, no, these things are unconstitutional. You're not allowed to do this. He tried to do this through executive orders, certain things. And the court said, you're not allowed to do this. These things are unconstitutional. One of the things he did, for instance, so here's an example of what he tried to do that was unconstitutional. FDR tried to boost agricultural prices by reducing surplus. So he said, I'm going to bring down the amount of product that's on the market, therefore I'm going to raise the prices of it. And of course, I'm raising prices and going to be able to reap more taxes from it, a backwards tax. But there was too much product on the market. America was producing well at the time. So FDR started buying livestock, buying cow, just to kill them, because he wanted to reduce the amount of supply that was on the market. So buying just to kill them. And then he got a little crazier. He said, well, I'm going to pay farmers to not plant on their own land. So I'm going to give farmers subsidies to not plant. Whole acreages of farms, basically going to confiscate by giving them money to not plant. Did he do this out of his own pocket? Of course not. FDR didn't have any money. So how did he raise the tax for the subsidies? Well, he started taxing other farmers and other manufacturers of farm products and saying, we're going to take money from you to pay individuals not to add to the supply, really ruining the economy, as it were, because he wanted to push forward his progressive ideologies. So he was price setting, causing supply chain issues, and then taking from others to pay government mismanagement. Does any of that sound familiar? Right? It's basically what's going on right now, and it was as unconstitutional then as it is now. Equally unconstitutional. And so FDR was mad, and he said, well, if Supreme Court, you're not going to vote my way, I'll just keep adding more people until I get my way. That was court packing then, and that was probably the most recent threat that we had up until now. Thankfully, Congress, who still had purview on the amount of justices, it was a very unpopular idea in Congress. It was also a very unpopular idea with the public. The public disagreed with what was going on. They saw right through FDR and what he was saying, and they identified it as court packing, and they did not like it. They rejected it. Even the Senate Judiciary Committee that was actually considering the bills, whether or not they wanted to expand the court, they said so harshly in response, they said that this bill was an invasion of judicial power, such as never been before attempted. It's such a dangerous abandonment of the constitutional principle. Right, that's the Senate Judiciary Committee then. Such strong words against what was wrong. If only we could have such a strong Senate Judiciary Committee now. The last time, just a few days ago, that the Senate Judiciary Committee met, there was an argument going back and forth between the witnesses and a sitting member on whether or not men could get pregnant. That's what our current Senate Judiciary Committee is concerned with at the time. Just like you're laughing, how much would that witness be laughed out of that seat if that's what the previous Senate Judiciary Committee would be listening to? So thankfully, this strong Senate Judiciary Committee in the 1930s rejected that. They called it a dangerous abandonment of constitutional principle. It said this is the worst intrusion into the judiciary that they've ever seen. And it's important that we listen to the words that they actually said, because it was a very strong repudiation from them when FDR wanted to pack the court. So where the left says now, oh, FDR, we see what you did then, but we're just going to raise you one. Our criteria is going to be even more extreme now than it was then, FDR. So now you're hearing not just that we ought to pack the court and that we ought to expand the number of justices, but representation matters. We have to have a certain type of individual that is appointed to the court, that you can't continue to have the same makeup. You have to have someone that encompasses the new winds of change in our culture. So you better believe now we need a trans, non-binary, woke, Buddhist internet blogger with like 300,000 TikTok uploads, not followers, uploads, right? That's the type of justice that we need. And they must drive a Prius, they must have dreadlocks. That's our ideal justice. And it's such a nonsensical description, right? But that's really what the left has reverted to.
Lord Jesus!
Right. So you have to ask, how do we repudiate against these things? How do we push back against really these wild ideas of what a justice is or what the court makeup is? Well, it's essential to understand what the role of the court is. What is the court actually there to do? The judiciary has to be completely independent of both branches that Norm mentioned yesterday, both the executive and the legislative branches. And so this Judiciary Committee, as they concluded then, they said, we have to preserve the court such that any idea that comes up that conflates the role of this court or future courts with the executive or the legislative has to be so rejected. We have to shut the door so emphatically that it can be never opened again. We can never open this door to being at the behest of the executive or these justices just being lawmakers. We have to make sure that there is really separation between these branches. And so the court concluded that any court packing bill, any way to overlap the powers must be so emphatically rejected that it never be opened again. And so at least for the last 150 years, we have this makeup of 9 justices that sort of corresponds to the amount of people in this country, but certainly just relies on its functionality, its ability to carry on the role that it was intended. But don't think that what FDR did failed altogether, right? We look at it back in history and say, well, you were so wild in proposing this, but he didn't fail altogether, and it's important for us to consider that now. He pressured the court later on to adopt what he ultimately wanted to do. It's sort of a watered down version, but he pressured the court to actually do it. They may have stopped court expansion, But just 5 years later, because of really his advocacy against the court, they ultimately held in favor of FDR. Remember that crazy law that he was proposing, saying that we're going to pay farmers not to plant on their own land? Well, 5 years later, just 5 years later, in Wickard v. Filburn, one of the most terrible decisions that came out of the court said, farmer, you cannot plant on, we're not going to pay you not to, you just can't plant on your land and consume your own food. You cannot consume the own food that is planted on your land for your own consumption. So it's not just you can't put this out in the market, you just can't eat your own food on your own land. And the reasoning they said is, if you can call it reasoning, they said, if you plant on your own land, then you're going to be eating your own product, and you're not going to go to the market to buy other people's product. And so what you do is going to affect the market. And since Congress has purview or control over commerce, we're going to say that we can stop you from planting on your own land. Stop you from eating your own wheat. That's still the law today. That's how they expanded interstate commerce. And if that sounds senseless and irrational to you, that's because it is senseless and irrational. It's buckwheat crazy is actually what it is. But that's the tactic that they used here. Supreme Court, you want to strike down this law as I propose it? Fine. We'll just keep peppering you and keep agitating you by saying we're going to pack you with new members. Supreme Court says, no, we can do our job. We don't need more team members. Then you're illegitimate. Yelling and screaming continues for the next 5 years. And ultimately, the Supreme Court caves and says, well, fine, we'll give you what you want. It only took about 5 years from their initial proposal to where he actually got his way. And it's a sinister approach, saying to the justices that if you don't rule our way, we're going to continue to attack you and harangue you such that you give us what you want. So that's really what is at stake. That's really what is going on now. The judiciary did remain relatively stable in their numbers, but they lost their ultimate principle by caving. And that's the danger that we do face today. The stakes are somewhat even greater than what FDR was dealing with. While FDR dealt with a country that was on the tail end of a depression, and so yes, individuals' financial interests were at stake, how the argument is being played out today, especially with the life issues, they're saying, no, individuals' bodily autonomy, women's bodily autonomy is at stake today. So court, this is so much more important. You have to eventually rule our way. And we know that's not true, but that's how they're framing the argument. But we know better. We know the contrary argument to that. We know that the right to life has been created because every individual is created through God's image, that it's his right that he's handed down to us, that laws ought to protect an individual from a moment of conception. We realize that the Supreme Court is one step closer to recognizing that by first rejecting the right of abortion. So we know there's a difference in how they're trying to frame this discussion. Nevertheless, this is what we're going to be continuously hearing, and the stakes seem even greater than what they were under FDR. That's the real threat that we're dealing with. The urgency and the visceral attack towards the court really is a lot greater than even FDR was seeing. And the left is going to double down, right? Maybe they don't get it today, but as they get more and more extreme, the pendulum is just going to swing higher and higher, go further and further to the left. And so in 5 to 10 years, when it finally does come crashing down, they may ultimately get their way, or they'll keep pushing until they get their way. What would otherwise seem as a radical approach now may 5 to 10 years from now be a very legitimate policy proposal. So what of this judiciary? How do we keep it the way it is? How do we keep the right judicial philosophy the way it is? What makes the judiciary so important and so critical to our concept of ordered liberty? What was the framers' conception of what a good judiciary was? Well, at a very minimum, it's an efficient backstop. It lends credibility to the rule of law. Laws are otherwise generally neutral, right? They apply to everyone equally. They're generally applicable. Of course, we know they're based on a moral framework. They have the undergirding of the Bible and our Judeo-Christian principles. But these laws are only effective if those that are submitted under their governance recognize that these are legitimate laws. In many ways, if we regard these laws as illegitimate, and those that are opining about the laws also as illegitimate, then they really have no bearing at all. If we don't have judges that are accurately applying different facts to the law without any favor or without any preference, then those laws really have no applicability all along. So that paradigm of us respecting the rule of law, this self-imposed rule of law, is so important, and the judges play an efficient backstop in order to be doing that. You know, really, these laws are how we decide to constrain ourselves. These are things that we've brought about ourselves. Obviously, we know that they're God-given, and it's through really his providential restraining force that these laws still have a preferential place in our society. But nevertheless, if we're not given the credibility to them and appointing judges that recognize their credibility, then they have no place at all. Of course, these laws are self-imposed. These are the constraints that we've placed on society. These protect our fundamental rights, and it's our own thing, right? When it's your own thing, you have ownership of it. You believe in it. And America's principles, its idea is really its own thing. It's so much more meaningful than what it was before, where the king dictated this is how things were, or an autocrat dictates this is how things were. In that framework, king is law instead of law being king. And so the justices and the judiciary is there to preserve that, to undergird this framing of our Constitution. It's the judiciary in the sense that becomes a slave of, or an officer of, or an agent of the law, keeping the relevance of the law there, because that's what the individuals within this country, underneath the Constitution, need to happen. The judges aren't the governing executive, right? They're not the king. We rejected that idea. They're not at the behest of the president. They are subject to what the law says. The judges aren't lawmakers either. They don't decree what the law is. They read the text for what it says and compare it to the text of the Constitution and see whether or not this is a valid law. And so this is how we established a system of government. It's stable, right? It separates the branches. It prevents any concentration of power between Article 1 or Article 2 or Article 3. None have a concentration of power, but it's spread between the three. It's really the check and balances. The justices don't allow the legislator to go off the rails in their new law creation, but it also checks the executive. It gives them parameters by which they can actually enforce the laws that are on the books. So the independence of the judiciary is so important that it's not at the behest of any of these other branches of government, but really at the behest of the Constitution. With that, it can reject any fickle public opinion. So public opinion sways back and forth, but if they're grounded to the text of the Constitution, then there's something solid that they can hold on to. And there are so many quotes over the years that we ought to turn to realize what an independent judiciary actually does. There's no shortage of really good quotes that talk about the role of judges. Even liberal Justice Sandra Day O'Connor said, "Judicial independence doesn't happen all by itself. It's difficult to create, and it is so easier than you can imagine to destroy or to damage." And we're really seeing that now. It's so easy to damage or to destroy just the legitimacy of the court, to which their angst or anger can be directed towards and ultimately have the court bow to whatever whims of the day they want to follow. John Locke was influential in saying that whenever law ends, tyranny begins. So if the law ends, if the pronouncement or the opinion of the correct law ends, then we fall right back into tyranny. John Marshall adds to this by saying, whenever courts suffer an invasion of their independence, whenever their independence is breached, then law ends. So for our doctrine, for our purposes, probably something that you should take away from this is that if we want to avoid tyranny, have law. To have law and avoid the loss of law, have judges be independent. So to avoid tyranny, have law. to avoid the loss of law, have our judges be independent. Because you could have everything down, right? You could have the best words in the Constitution written down. Everything that's necessary for the outworking of the law can be there, but those things are just going to rest on paper if the citizenry don't adopt and believe it, and if the justices don't construct it and order it and rule consistent to that law. To that end, one senator was credited in saying that written compacts and charters can be no more effective than the guarantors of liberty. And the vitality, the life given to those written charters or the Constitution is given to them by an independent judiciary who are charged with the duty of construction, charged with the duty of making sure it is rightly enforced. And to think that judges have to be special, right? That there's some special calling over justices, that they have to be some elite group of isolated individuals, that's not right. We understood that just reading the text of the Constitution, reading the text of the laws that come in front of you ought to qualify an individual for being a judge. Yes, they have a distinct role that contributes to the unique independent concept of ordered liberty. But even Justice Gorsuch was right in saying that when judges don our robes, when we don our robes, it doesn't make us any smarter, right? Justices are not any smarter, but it's just a reminder of what is expected of us. And what is expected of any justice, what is expected of any of you when you do become a justice, is impartiality, independence, collegiality, and courage. Very simple. And if you're adhering to the text of the Constitution, if you're impartial, if you're independent, if you have the courage to do the right thing, and you're getting along with your other justices, then you can be a justice of the court. Those are the parameters put on individuals to be qualified as justices of the court. And one of the best definitions also comes from Alexander Hamilton. And Justice Scalia repeated these words, that if you're doing the right thing when it comes to the Constitution and the laws and the text of the laws that come in front of you, then you will have to occasionally tolerate an unpopular decision. At times, you may reach an end that you don't actually agree with. But that allows these decisions that come out not to be swayed by popular demand, not to be swayed by winds of change, but are deeply rooted within the text of the Constitution. And the only hope that a constitutional republic has, or the hope of it thriving, is that yes, at times you may get to decisions that are unpopular, that the rest of the public doesn't really think is the right way. Does the left agree with that? Of course not, right? The justices can only do what the left want in their eyes. And so they have attacked the judiciary. They've done so in such a dramatic way. The first way that they attack them is try to deter good individuals from wanting to be justices. So whenever a justice tries to get confirmed, yourself here, they'll go through your history, they'll make up lies and visceral in order to deter individuals from wanting to be judges or wanting to pursue this career of being a justice. There are two instances in our recent history that really mark just the visceral that they will do against an individual that's working their way up to become a justice. The first is the way the Senate in the 90s treated who's currently the longest serving member on the court, Justice Clarence Thomas. He's the only black male serving currently on the court. And also the way that they treated Brett Kavanaugh in his recent confirmation. They do so in order to deter individuals from wanting to be part of the process. How many good men have decided, I don't want to go through this? How many good women have said, I don't want them parsing through my life like this. There's no way I'm going to follow this up. And they also do this in order to deter presidents from sticking by them. Imagine what would have happened if George H. Bush decided, Clarence Thomas, too much heat around him, I don't want to continue with this. Or if President Trump decided, Kavanaugh, I don't know, man, I don't really want to stick with you through these confirmations. So the baseless accusations that are levied against individuals, even through their confirmation process, is one of the ways that the Democrats and really the left try to politicize, try to control, and try to pressure the court, saying that we're going to keep you so contained to this narrative that we have about you that even when you're on the court, anything that you do, we're going to say, no, it's illegitimate. Look at the man that came out with this decision. Look at the woman that came out with the decision. It's a way not only to keep them off the court, but to sway presidents against placing them on the court, but also to try to neutralize them when they're on the bench, calling everything that they do now illegitimate. Even if what they do is correct and legally sound, the media and the left comes after these justices in order to sway public opinion against the personalities of these justices so that anything they do is considered illegitimate. And you've seen it recently. Some of the worst racist comments that have been levied against any public official just came out in the last few days against Justice Thomas because he voted against the way the left wanted him to do. They didn't just stop at him, they attacked his wife, they attacked their interracial marriage. They even accused the justices of being influenced by prayer. They said it's the influence of prayer, sort of like a mirage or an aura, that they're in a trance. That's why they went and ruled against abortion. Like there was a mirage over their head. It is a new one, but if you look at the court, so my office is right across the street from the court, and it's on four corners. And apparently in witchcraft, if you control the four corners of an area, you're able to put a demonic influence. And so all day, if I were to pull up on my phone, my office camera right now, you'd probably see witches and warlocks trying to reverse the prayer that has been done over these justices and place a hex on them. So that's the attack really that they have on the personality of these justices, that they have on the legitimacy of the court. But they also have done something so extreme. One of the things that they did was very extreme in the way that they tried to persuade the court. And that was in this leak leading up to the Dobbs decision. The fact on May 2nd, they actually leaked, someone within the court, a clerk perhaps, leaked the Dobbs decision. They did so intentionally, right? They wanted to stoke up fear, stoke up unrest, sway the justices, continue to threaten them and say, you know, we're going to put this public and legislative pressure on you such that you don't go forward with the decision. And it's hard to describe just how egregious a breach of that nature actually was. The fact that they leaked it. And they'll compare and say, well, this has happened before in history. No, it hasn't. This is the first time in history that a decision, almost in its final form, was leaked to the media in order to sway opinions, with the sole purpose of stoking anger and stoking unrest, hoping to convince these justices to change their mind. And like I said, my office is right across the street from the court, so I know former clerks, right? It's a very small number of individuals that would have had access to that. It'd probably take between 5 to 8 hours of good investigation to sit them all in a room just like this and whittle down to who they actually thought could do it, so they could uncover what it was. But have they done that? Did the left get in any trouble? No, that individual will probably get a 10-year law professorship wherever they want to go to. They may lose their license, but they've effectively done what they wanted to do. Try to delegitimize the court and set a standard that, hey, if you really don't like what's going on, here's a good tactic to release an opinion before it comes out. The Biden administration used this leak strategically to pressure the court. Leftist activists were in front of the homes of the justices, and you didn't see any reaction from the Biden administration. Even though there's federal laws that said you cannot intimidate or interfere with a justice's pronouncement, nothing came out of the Biden administration. The DOJ was never summoned. They never investigated. There was no protection put out. It was the local Commonwealth of Virginia or the state of Maryland that decided to protect the justices. Nothing came from the Biden administration. There was a man recently arrested in front of Kavanaugh's home with guns and body armor, basically saying, I want the justice to change his mind on this. But what'd you get from the White House? You just got a shrug of the shoulders. From the Senate, you got many more words talking about the illegitimacy of the court, stoking up this fear and unrest. You'll remember in 2020 when Chuck Schumer says, I'm going to try to mimic him, I want to tell you, Justice Kavanaugh and Justice Gorsuch, you have unleashed a whirlwind and you will pay the price. Right, that's my Chuck Schumer impersonation. But was that good? I gotta like hobble over now, back to my chair. But even the senator from this state basically says, if you think you've seen a revolution, go ahead and outlaw Roe v. Wade and see what our response is. right? These are what sitting senators on the court are saying in an attempt to delegitimize the court. And we saw not just an attack on the institution itself, but also individuals that did agree with what the court did, like these pregnancy resource centers that are now almost 37, if not more, being attacked. Several churches having their church services interrupted. That's really what the mob does, right? It tries to delegitimize, it stokes public anger and angst towards the court. And their entire attempt is to have the justices revise the decision or influence the judges or stoke fear, ultimately trying to delegitimize the court. All because the justices did exactly what they were required to do. They overruled what was really the deadliest decision that we've had, the Roe v. Wade decision. And so lastly, with the remaining time, just to show you what the justices did in a good way, we're going to quickly go through the decision, because not only does it walk through the decision properly, as an opinion ought to do, but it also sets out good judicial philosophy. It's an instruction to future lawyers and to future justices. This is how you properly go through a decision. So in our remaining time, we're going to run through some of the highlights in the legal structure of the Dobbs decision, talk about its constitutionality, and really set out how good justices came to overturning Roe v. Wade. Of course, as mentioned, Justice Alito's words, right? The Constitution does not confer a right to abortion. But the opinion goes on to say Roe was egregiously wrong from the start. And that word egregiously wrong from the start is critical. It'll come up later when we talk about stare decisis. It says no such right is implicitly protected by any constitutional provision, including the one in which the defenders of Roe now chiefly rely. And I call this opinion both patient and principled. Patient and principled. It's patient in that it calmly walks any reader through the history of abortion up until this point. So they really patiently did the job that a justice ought to do. They looked back through the common law and saw that the common law always had a crime of abortion. The law protected the life of a child if the mother could feel it moving, and even if the mother couldn't feel it moving, the justices said, the common law always protected that right. It talks about how an individual would be twice guilty of murder if it tried to harm the mother and it harmed the child. Or if they concocted a potion that would target the child and it harmed the mother, the individual would be twice guilty of murder. So the justices walk through the common law and say, no, in our common law, we always recognize the life within the womb. Never before in the history of our country has a negative law or a negative right become a fundamental constitutional right. So never did a do not completely flip and become, no, this is an actual right. That leap could never be justified by the Constitution, and the justices were very patient in walking individuals through. And we can see the cobbling together that the Roe decision was. They picked up an amendment here and picked up an amendment there and said, out of the penumbras, right, out of the emanations of these amendments, do we find this right to privacy and this right to kill a child? And so the justices walking patiently through that said, no, that was egregiously wrong. There is nothing here that gets us to the point of the right to an abortion. It had no basis in the law. So it's very principled in that sense. Very patient, I should say, in that sense. And it was also patient in that it walked the reader through the stages of life. So Mississippi actually put that in their law, walking through the stages of life, and so did the justices, right? Looking at the text, talking about the different stages of fetal development, from the eyelids forming to the fingers and the toes and the unique fingerprint and the heartbeat. It lets the reader understand that's why the state has an interest in preserving this life, because we can walk through and see the stages of development of life. It leads the reader to understand that that's really the interest of the state, and that this false pronouncement of Roe never got to that point because they never actually considered what was going on in the womb, right? The Roe decision played lawmaker. They said, we don't really know what's going on in the womb, and so we're just going to say, well, there's this trimester standard and there's more protections that apply here versus there, and we'll basically throw this to the wind and see what happens. So in contrary to that, it was very patient in how these justices walked through the Dobbs decision. But it was also principled, right? They did the actual work of going through what the law says and how the law will be interpreted. It did the work that an opinion had to do, and the interpretive lens by which any judge going forward ought to read the law in a strict original sense. Not fabricating rights that are not in the Constitution, but really looking at the text and looking at what the founders intended in its original sense. And it's so important what they did, why it was so principled what they did, because every lawyer that's practicing in the country now, and every law student that comes, certainly during my time, we had to study Roe v. Wade, right? We had to study it in law school, we had to read it, you had to memorize its facts, we had to dispute its underlying premises. You had to both study and you had to teach it as law. But all that now is shattered, it's eviscerated. No longer will that philosophy of law be properly communicated even to the lawyers that are going to school now and the future justices. It's so important what they did in eviscerating that standard from our laws. You no longer have to teach it. Very strong. And that doesn't just affect the United States, it affects the rest of the world, right? It signals to the rest of the world, this is exactly how the United States treats its Constitution. This is the respect that it gives to its Constitution. It's so principled in how it works through some of the headlines or head notes that you have to discuss when discussing law, like equal protection. Equal protection is basically saying that the state can't favor certain things based on a protected status. If an individual has a protected status, they can't give partiality to one status over another. Everyone has to be equal protection. So the argument is, well, this is favoring men over women. This is basically saying that Roe did the right thing in balancing the equality of men and women because, which is true, it is only a specific class of individuals that can get pregnant, right? It's women that can get, Senate Judiciary, it's women that can get pregnant, right? So the argument is, well, this puts women back on parity with men. So the justices didn't ignore that, they had to address it. And they said, no, this isn't pitting a woman's value judgment against womanhood. It's not pitting a woman against her value judgment, saying that the only way that your judgment has value is by you being able to exercise a so-called right. What the justices did, it says, no, this decision, this pro-life decision is going to pit the practice of abortion versus the life of the child. And it's a fundamental shift in perspective. It's taking the argument away from saying it's a man versus woman issue or a woman versus her principled decision issue. It's saying, no, we're going to pit the actual practice of abortion versus the value of life. And that shifts away purpose, which is a very critical thing that they had to work through, and they weren't afraid to address it. They also address substantive due process, and this is very important, this area of substantive due process. The 14th Amendment does sort of leave this nebulous idea out there that there are other rights that can be read into the Constitution that aren't actually there. But there's still a standard, and the justices work through what that standard is. There's a twofold standard that, one, it has to be deeply rooted in the history and tradition of the country, or it has to be implicit to the concept of ordered liberty. So if that right isn't explicit, it has to be, one, deeply rooted in the history and tradition of the country, and implicit to the concept of ordered liberty. And as mentioned, there was nothing deeply rooted about abortion. There's nothing about the ordered liberty with regard to the so-called right of abortion. It was the exact opposite, and the justices were good about going through the history and tradition and why ordered liberty did not confer this right. And ultimately, they got to this point of saying, therefore, it is an inescapable conclusion that the right of abortion is not in the nation's history of tradition. They went through all the history and said, no, we never got to that point. And that's so important because although attitudes had changed, right, individual attitudes probably changed when it came to abortion from the inception of this country through 1973. There was nothing there in our history and tradition or an originalist sense of the Constitution that ever would get us to that point. This is the very last thing that they did with regard to stare decisis. So Justice Sotomayor said, no, for the integrity of the court, we have to do things consistently. We can't have a differing opinion than what we did in the past. We have to remain consistent to our stare decisis. Well, stare decisis doesn't compel an unending adherence to the abuse of judicial authority. If the courts get it wrong, the courts get it wrong. They got it wrong in Dred Scott. They got it wrong in Plessy v. Ferguson. And so there are a number of factors to determine this is whether or not the judiciary has got it wrong. The factors are the nature of the court's error, the quality of the reasoning, or the workability and effect of other laws. And so the justices went through stare decisis and said, no, based on these factors, the court got it, and here's where the word egregiously come out. They didn't just get it wrong, they got it egregiously wrong. It is so far off what the justices are supposed to be doing in interpreting a law that stare decisis can't hold the day. Oh, and by the way, as Kavanaugh pointed to, there are so many things that we had to overrule. We had to overrule a Dred Scott. We had to overrule a Plessy v. Ferguson. We had to put in place a Brown versus Board, and stare decisis principles allow us to do that. Stare decisis principles allow us to overturn Roe v. Wade and get to this Dobbs decision. You can correct a bad so-called constitutional decision. And what that does is takes the idea out of the makeup of that current court and brings it back to actual principles. Is there something within our actual principles that we can turn to that the court got wrong? So that is how a bad decision becomes a good decision, or that is how a proper judicial philosophy working through what needs to be done, the work of the justice is done. And that's essentially what Article 3 maintains that justices ought to do. So what a great time, once again, to see what good justices are able to do, to see the work that they're able to put forward. A grand summation of what this term looked like. Remember, we started off this term dealing with church reopenings, right? And we've ended here to where we are. So a grand summation of what proper justices do. The doctrine, really, that we get from this last term is that churches have a right to worship and that they can remain open even in a crisis. That individuals of faith can take that belief into a public square and have their viewpoint recognized in the public square. That should sound familiar because you can have your viewpoint recognized in the public square. You can fly your flag in the public square. That Christians can take their money, this came out of the case in Maine, you can take your money and have it follow your children even to Christian education. They can go to schools. Even when they're in those schools, those teachers can now bear arms and protect the students within those schools. And individuals have a constitutional right to bear arms. They don't need preferential treatment or to have to show good cause in order to bear arms. That when students are playing sports, even in a public setting, that their teachers and their coach can actually pray over them and pray in public over them, over their safety. And that came out of the Coach Kennedy case. You can actually pray and still maintain your constitutional right to freedom of expression and walk through the schoolhouse gate. And oh, and by the way, babies have a right to live. Right? To say that this is probably one of the most consequential moments in American jurisprudence, in our philosophy of law, that's a very accurate way to say it. It's consequential. But to that I say, every time there is such a consequential moment, anytime there's a recognition of our fundamental rights, there's always a corresponding responsibility. There's always a corresponding duty that comes with those rights. The framers did one heck of a job getting us to this place. But those rights are no good if they're just hanging on a shelf. Their expectation is that we would be actively engaged in the very activity that necessitated a recognition of those rights. And we would be actively engaged in any number of these rights. And so we have to be committed to doing those things. We have to be committed to publicly expressing our faith, returning thanks to God for a nation and a people, and Article 1, 2, and 3 that at least recognizes on paper God as its creator. But you and I know even better that one day they'll have to recognize God as king. And he's given us the responsibility, the right and the duty to get that culture from that place of just creator to recognizing him as king. And that Article 1, 2, and really 3, that preserving the independence of the judiciary and rightly interpreting our laws is a very strong way to get that. So let's use that duty to share with the world this one message that they need to hear the most. Thank you.